Hello, and thank you for joining us for the third episode of the SLW Institute's Patent Analytics webinar series. Today's episode is entitled Using Prosecution Analytics to Improve Prosecution Efficiency and Identify Wasteful, Unproductive Prosecution Spending. A recording of the webinar and the slides will be emailed to all registrants. Please feel free to enter any questions in the Q&A feature in the Zoom menu. This is the third episode of an 8-part series. Episode 4, Using Examiner Analytics to Improve Prosecution Efficiency and Develop Well-Informed, Data-Driven Prosecution Decisions and Strategy, will take place on May 28th. Today's episode will be moderated by Steve Lundberg. And with that, I'll hand things over to Steve.
Hi, everybody. Welcome to our third episode in our analytics series. Glad to have everybody back. In the lineup today, we have another couple of people that have been with us before. Tom Marlowe, who's president of renewals and also analytics services at Black Hills IP. Tom was a former chief patent counsel of Fairchild Semiconductor, is in private practice for some time before that. Also back with us today is Mark Stignani, who's the analytics chair at Schwegman firm. Also, Mark was a former chief patent counsel himself and has been in private practice a long time. Also joining us today is Russ Slifer, who's CEO of Black Hills IP and the former USPTO deputy director. Also was in private practice and former chief patent counsel of Micron Semiconductor. So we've got quite a lot of knowledge on our panel today, and we look forward to hearing what they're going to tell us. Next slide, please. So start out here, just a little bit of what are prosecution analytics, and mainly I want to distinguish these from examiner analytics, which we're going to address next week. Obviously, these are somewhat two different sides of the same coin, in the sense that the analytics we're looking at a lot of times are more or less shared between the patent office and a prosecution firm. But of course, the patent office has their one side of it, and then each law firm has their sort of window into each art unit and how they interact with it. So each law firm, each group inside of a corporation prosecution team will have their sort of analytics that are separate and distinct from those at the patent office for whatever areas they're working in, but it will of course parallel that. But what we're going to do today is just look at what can we derive from prosecution analytics from a prosecutor's performance perspective? What kind of insights can we get? How can we use those insights perhaps to be more effective, identify patterns that might be useful to us? And let me just say up front, this is an area that we have some experience in, and we've looked at this data a lot, but we are really interested today in what other people have done. If they want to share some comments, on the chat or in the Q&A with things they've done or things that they've found useful, we would really like to hear from the audience today about that, because we're still learning as we go. So with that, let's go to the next slide. So what we're going to try to do today is just going to figure out who uses these, what are they good for, when do you use them, what kind of insights might we get, what types of analytics we're going to look at, how they're generated, and then talk about tools a little bit. Next slide. Before I jump into this, I just want to note that Russ Slifer and Tom Marlowe might be a little bit late. I don't know if they're on the call yet or not, but they were on another webinar just before this one with Patrick's, one of the IP providers that Black Hills works with a lot. And just while I'm on the topic, put a plug into Patrick's, which has a really nice open API and has really embraced the open API movement in IP. where everybody can share data freely between systems, and everybody can work back and forth in everybody's systems. So thanks to Patrick's for that. And of course, I've mentioned before, CPA Global also has some nice open APIs, as well as AppCall and CPI also. So they're all get kudos, and encourage those companies that are not yet embracing that to also get on board and kind of help the industry move forward. So let's talk a little bit about, what we may try to find out today. We're going to look at how you might use these prosecution analytics for cost projections. We might try to derive some best practices from them. We might try to derive some bad practices, try to figure out how to use it for cost management, while prosecution is in flight. How we might basically look at these analytics if we're acquiring a portfolio, maybe talk about using them for outcome management, and then maybe compare your analytics with competitors to see, differences in how those look, and try to figure out what that means, if anything. And the users of these obviously are going to be corporate prosecution management, and then law firm management for helping the law firm to become a better law firm. So with that, I'm going to turn it over to Mark Stignani and let him take it from here.
Thanks a lot, Steve. I appreciate the opportunity here. So the one thing that's different about prosecution analytics versus the examiner analytics is this is an area that law firms, as well as corporate clients who are managing these processes, they have a lot more power control in this. So they have a lot more, I guess, it is something we can just observe and ruminate over, as we might in the examiner side. But we can actually engage actively here in management of a portfolio and understand, the things that go through the day in and day out management of prosecution. So we are very focused on identifying financial statistics, that the cost to draft, cost to prosecute, cost to grant, as we'll talk about a little later. We are very focused as, identifying, very quantitative areas like what's the page counts for, the claim counts for, the drawing counts, whether or not there are unique words, unique nouns being used, or is the drafter reusing a lot of pre-existing boilerplate. In the prosecution side, though, we count lots of things, and we're going to engage in this as we're going through. I also, echoing Steve, is that if you guys have questions or commentary on things you'd like to use, you find particularly useful, we invite you to add them to the conversation we're having here, because as this is pair data has been fairly available through various means for about the last 4 or 5 years, but really the analytics around that and the prosecution analytics and the inferences we can take from these things has really started, really the ball's really just started this year, or maybe fall of last year. So there's a lot of good stuff happening in this area. I want to certainly encourage people to think about this. So I'll let you read the types of stats we use. Let's move on to the next slide. So what can they tell us when they cannot tell us? I mean, there's the old adage about lying through statistics. So as we're going through this, that quantitative analysis can show us lots of things that might be best cases. They might be best portfolios, and they might be best firms. But as we'll have a non-trivial example later on, which helps us understand where using those things can be a double-edged sword. Sometimes you may throw the baby out with the bathwater if you're looking at this as firm management. So we look at lots of things in a comparative statement. So we look at our clients' stats versus the competitors' stats versus how the law firms working for them are doing. So we love to pivot around very statistical views of prosecution history, but we always want to make sure that you add a qualitative view on top of that. So what quantitative can't tell us, and this is where we go to qualitative, is what is the quality of the firm? What is the quality of the attorneys working on? What are these stats doing? Are they more likely driven by the corporation or the client? Are they driven by budgetary concerns? So, in some cases, are they a result of vanity or an inventor who exerts an awful lot of power over the prosecution put forth by, say an institution like a university or stuff, where professors have a lot more say in what gets prosecuted. So again, this is the world we're working in here, and so we've been working on trying to figure out whether or not there's a good value in going one more office action into a prosecution, one more RCE into an office action. A lot of this, and I'm stealing a term from Russ, is really about genomically going through everything that we can tell about a patent prosecution or a portfolio, and extracting things that look the same, act the same, and then therefore by inspection will give us the ability to make some judgments about financial investment into the next round of actions in prosecution. Next slide. And also, anybody else in the panel, just jump right in here if you have anything else to say on this. So the statistics help us, and I can't overemphasize this enough, that budgeting, especially in this time, is of utmost concern to many, many clients. So what we want to help people understand is what's stuck in prosecution, what potentially is stale in prosecution, rather than going down the road with one more RCE, which can run you between $2,000 and $7,000 if you add in 2 office actions. Is it better to file a continuation and start over on a focused approach that you want to go into? Again, back to prosecution decisions and things like that. You can use it to evaluate your counsel, but that comes with a bit of pitfalls, and we'll cover later. But we really find this is useful in acquisition pairing. So as you're looking at targets, pairing the prosecution statistics of an acquisition, I think, are very useful. And then also in licensing, if you're asserting a license or you're receiving an assertion for a license, both of these help you understand encumbrance, other flaws in the portfolio during its prosecution. So a lot of these things in have. So Russ and Tom, if you're there, could you also kind of?
Yeah, one of the other areas that I've seen this too is like in a joint venture type situation, where a lot of times as part of the negotiation, you're figuring out who's going to manage the filing and prosecution of any jointly developed technology. Getting a sense of what the parties' practices are, how they might differ, might give you I guess, or help your decision making in determining, do I want to be pushing for managing the prosecution here, or do I feel comfortable with the other party doing it, that they're going to get quality IP that I'm going to own a piece of?
And
Yeah,
Tom, this is Steve. Maybe you could just comment on, so what are some of the statistical indicators that you might look at to make such a to get some insight?
Sure. So yeah, in that case, you're talking about in some cases like the length of the spec, the length of the claims. Obviously, none of this is conclusive in and of itself, but it gives you a place to start from, to dig in. In addition to how prosecution tends to go, did they get a lot of first office, first action allowances? Do they have multiple RCEs? I'm sure some of what we're going to be going into here, but just to get a sense of, is it, do we wind up with claim sets that start very broad and wind up extremely narrow? Do we start with good kind of focused claim sets and end up with good focused claim sets? Those types of things. The data that really starts to tell you where those needles lean, I guess, is kind of the way to put it.
Yeah.
And this is Russ. I jump in here and take another thought on this, and that is, when you're managing a large portfolio with a lot of outside providers, or across different business units, maybe you've got a large in-house group with, different attorneys managing different divisions. It's difficult when you get into a economic position like we're in now, or like when I was back in 2009, and you've got to make some difficult decisions. Where am I going to put my budget? which law firms am I going to keep, which ones am I going to reduce work to. And often if you go to your in-house team, or you just kind of, you get anecdotal information. This is the firm I like to work with. This is the firm that's good. And everybody's built relationships. So they're going to advocate for the ones that they like to work with. So I think using prosecution analytics at least provides a level of, I guess, a base level, a level to compare. It's not going to give you the answers. You already pointed out the fact that there are certain things you're not going to be able to become actionable based on the data, but it certainly gives you some information to assist in that evaluation in kind of an objective standpoint. So I think, you know, what we're talking about today can help in a lot of different areas, even in evaluating. I think you might point out later, if you have a acquisition in the portfolio, I had this come up a lot when I was managing, is, you know, we would buy a company and there'd be another 6 law firms that would come on board with that portfolio. And I needed to make a decision whether I was going to move that portfolio to existing law firms I was working with, or keep it with the ones that the acquired company had been using. So those are a couple of ways that stats can help.
Yeah, and in that M&A type of setting, even if you've got those stats on your current firms, kind of good or bad, just being able to compare them together kind of gets back to, Mark, the point you made about like genetics. If you look at the data, here's the incoming firms, here's how I've been managing, what's different. And again, the analytics aren't conclusive, but it gives you a place to start to say, well, okay, this piece seems to be off. There's more interviews here. There's more RCE practice here. Why is that? And then you can at least go into the analysis with a little bit of information.
Yeah, absolutely agree with you. I mean, I've probably done over 500 acquisitions during my corporate time, and the DNA of the portfolio, whether it was, did they file lots of provisionals as a startup to boost their valuation when they're purchased, how much effort was put into these. Are these $5,000 applications? Are these $10,000 applications? I think those types of fiscal evaluations are really useful. And the joint venture stuff, I think, is really important as well, because prosecution statistics, especially around inventors, I think comes into an area that is often ignored in this area. So let's move to the next slide. So, this is my list of useful metrics that, these are kind of all in my start place. So quantitatively, I look a lot at firm to PTO, because firm to PTO is something that's, generally within the wheelhouse of the firm itself, and how well it does or what it can do. Now, I say that generally. In many cases, there are exceptions where a corporate client has taken large control of various aspects and behaviors, where this is not wholly in the firm control. But I find these very useful in kind of a first assessment run through of a law firm and their performance. So the pendency of the matters they have, how long have they taken? Do they amend, or how much of expansion have they put into their amendments? The office actions, average office action per matter, I think is highly useful. If one firm is, predominantly in 3 and 4 office action counts, and another firm is not, definitely worth a moment to look deeper into that. Interviews is another area I think that requires a fair amount of investigation, because I find that interviews tend to have general positive effect with amendments and success of those office actions to drive to an allowance. So we like to look at interviews and what is the success rate of those interviews. This again will bookend with our next webinar, where we talk about all the interesting things we can find out about the examiners and the art units and the tech centers. So again, always a good look at RCE counts. So RCEs are an interesting aspect of company evaluation as well, because if I find generally companies are the ones driving RCEs, and so we'll see unreasonably large numbers of RCEs with certain evaluations we see, and we try to figure out why that is, and it's across many of the law firms. Extensions taken is another thing that's kind of blended between the corporations and the law firms, because we've all had inventors who take longer to respond to your action. So you take an extension, but I find that we like to take a view of how many extensions are taken by clients or with clients, and we try to drive that down so that we're not incurring extra fees for our clients as we're going through that. Restrictions are also another count that we look at. A lot of the restrictions, I think, are also endemic to the examiner statistics. But again, it's how do you respond to restriction? Are you fighting to reverse? Are you not fighting to reverse those as you're going to responses? Appeal win weights are also useful. But then what's kind of coming, I think, in vogue, and I think is a fairly significant useful stat, is how well they're doing for their clients. Are there how many one-on-one rejections have they overcome? Have they generated 102s against a competitor in their own funds, or at least a primary 103? So I find that those statistics have really good probative value as you're looking quantitatively at a firm or at a client or at a prospect or competitor. Yes, go ahead.
Mark, this is Russ. I'm going to hop, if you don't mind, hop in real quick.
Oh, please.
This is a total tangent, and I apologize
please
for this, but I can't help but speak up when I see the appeal win rate. One of the things that I worked very hard at when I was at the PTO was to get the backlog at the PTAB down to make appeals more viable, or at least as viable as RCEs. And right now, across the board, the appeal time is down almost, in some areas, under 12 months. So just wanted to point that out, because I've noticed, talking to people, that a lot of the general patenting public doesn't realize that is a viable strategy now to get the PTAB to weigh in instead of churning, if you will, with an examiner. Pointing that out as something to think about, but also as down the road looking at these statistics, there should hopefully be at least if not a knee in the curve, a change on number of appeals and how that's coming out.
Absolutely. Well, thank you, Russ. And you do bring up a very important qualification I wanted to talk about on these stats, is that time slicing your data is key. What's happened in the last year, what's happened in the last 5 years needs to be interpreted in light of other things that happen outside the patent office. You can look at acquisitions and other, even social data by the inventors. So time slicing, which I haven't mentioned here, is really crucial in how you think about making a successful analysis of this. So
and Mark,
but,
can I
yeah.
just
Sure.
jump in just to elaborate on that a little bit? But because we ran into this quite a bit when we were looking, doing some machine learning stuff on, just what examiner stats and stuff, which is, the time frame that you analyze is really crucial, particularly around milestone events like changes in patent office guidance or post major case. So if there's a major 101 case, for example, comes out, that can really cause an abrupt change in outcomes going forward from that date. So if you don't take that into account, you're averaging in stuff that was before and after that. It blurs your actual picture of what's actually happening. But I've got a question here, I think, or I've got Ed Sander, who's raised his hand for something. I'm not sure if he has a question or not, but if you do, Ed, can you shoot it up onto the questions? But time. That's my point on that. So we can move ahead. Ed, please put in a question if you've got one.
Yeah, and so if we jump over to the firm to client side, so this is where I think a lot more value is added by the law firm in analytics, because cost of grant and cost of grant and continuations, I think is a really kind of a different way to present your data to your client, because as they're managing their budget, they generally will get a cost for filing. You'll understand the fee that you'll have a cost for office actions, but a total cost of grant calculation is I think a useful metric to work with. Claim coverage versus cost. So I mean, again, it's very easy to get narrow claims through the system, but they're also marginal value, unless you just want it to cover something you're looking for a patent count. So it's another value add that we can work with our clients. Also, allowance rate claim scope. I still don't know of a single tool out there that helps you understand claim scope. And competitor impact. So competitor impact we can generate through rejections, through projected claim coverage for a product on evidence of use. So we can merge all these other things that help us lift to the qualitative level other support for the types of conclusions we're going to put forward. And this brings us to a place where you can actually start to tell your client what is the theoretical value of the next office action is going to give you as you're prosecuting this matter, or what is the next theoretical value of an RCE here versus in going straight into an appeal. And again, this dovetails. These are the bookends of what you can control here on this side of the thing versus what an actual examiner may or may not do. And in that respect, the examiner stats are much more cut and dried as to how they may or may not rule on a particular matter and what their win-loss statistics are. So I find giving clientele firm to client, a much more thoughtful and a better way to be evaluated as we're doing good prosecution for them.
Hey, Mark, may I jump in there?
Sure.
This sort of makes, as you're speaking there, sort of makes me wonder, and I'm sure a lot of people wonder, we look at the art unit stats or even examiner stats, but then the flip side of that are all these stats for each of the individual law firms or attorneys or groups inside of a corporation that may be different from firm to firm against, a single stat for an art unit. So those kinds of stats would be very interesting to see, right?
Yes.
Yeah.
And we can certainly create overlays that helps you understand, how a particular law firm is performing in a particular art unit. This started probably back in the 101 rejection or 101 subject matter days when we, started to really kind of see who's doing better in particular art units, especially against the 101 rejection. So we can get really, really granular into that analysis, and I think it's very useful to discuss.
Mark, I have a question. When it comes to those, I guess the cost statistics or the cost analytics that you've got, in which are great because once you start putting dollar signs on things, I think especially inside corporations, the attention raises, right?
Yes.
Maybe a good way to put it. In your practice, how important is it have you found it to have really accurate cost numbers versus, just kind of good enough estimates? Like, are estimates good enough because a lot of this is relative statistics, or, kind of the other side of that?
It's a little column A and a little column B, Tom. So
Sure.
We work with as many average values or benchmark values as we can find on that are reliable on the web to give informative estimates on how much a competitor might be spending. AIPLA economic survey is another good source of data. Not conclusive entirely, but it's a good source of data. Or most of our larger clients clients have some sort of fee metric that they're generating right out of their system. So they should be able to give you their average cost for office action and their average cost for RCE directly. So, depending on how well you partnered with a client, you can give them column A with an estimate of what their competitors are doing, and then they can come back and say, well, we're paying this much. So, and this really helps, I think, in discussing with your client around, fixed fee costs, alternative fee arrangements, because, in some aspect, we can put analytics on tail to say you get what you pay for. And here's the quality reasons why, this might cost you a hair more. So, in my practice, especially when we're looking at competitive outlays of, how much is a particular competitor spending to get their patents issued, how stuck are they in the patent office, who are they having success of? Is there a particular examiner who's being more nice to a particular client or a particular competitor, and again, stuff that which we'll talk about in a couple of weeks, but it's very, very interesting, I think, to a lot of clients to hear this.
So let me jump in here with a real life sort of story to put some of this a little bit in context for the value of it. It's so Schwegman a while back we're not representing this client at present, but we went in and we were doing our annual review with the client, and we're looking through the stats, and there's a bunch of stats they were showing us, and it was sort of like, some of them were like, looked like we were taking a little bit longer to get cases issued, and a few more RCEs, and so we're kind of rated, we're kind of below average, we want to be above average, below average, and then we get to the last slide, and it's like value of patents generated by firm, and like out of 20 firms, we were rated number 2 for the quality of the patents being issued. But up to that slide, you would possibly think we weren't doing such a great job. And so I do think, these stats can be very misleading. So I did want to add that comment that at the end of the day, it's, what you come out of the patent office with. And, you might have a firm that looks terrible on statistics, but it's coming out with great patents. So again, you got to take all this stuff, in context. So you
Absolutely.
Go ahead. And
yeah, we can switch to the next slide if everybody else is joining. And so, it's just a little quick dive. We've mentioned a lot of this ahead of time here, but the DNA, the genotyping of a prosecution portfolio that you're looking to acquire, I think is very useful. I'll let anybody else jump in here, and we can just keep moving along here as I want to make sure we get through all the slides and have decent time for questions. And so let's just jump in here again. I don't think I can emphasize this enough, because what we've got here is quantitative is always a starting point. I think quantitative will show you the outliers. I mean, the really significant outliers, but and I think that aggregated always is a better approach than an individual by individual look, because each patent has its own statistics, its own prosecution analytics, but each one can be a red herring, but in aggregate, they tend to tell a better picture. So conclusions you have should be validated. I like to pivot all of my quantitative data around a common assignee and a common technology unit, and potentially a common art unit, to make sure that we're really looking at apples to apples, and rather than something unrelated. And I'd like to also interpret in light of the business, and also time slicing. I mean, we hit that pretty hard, because a lot of in-house IP strategy changes with the leadership they have in there. So as leaders change, what was commonly accepted IP strategy goes out the door and is replaced by the particular brand of IP strategy the new leadership has put in. So I like to look at the inventors, because inventors tend to stick around longer than leadership. They tend to be indicative of how well or how prolific something might be drawn, the product line itself, and again, how supervision is done. you know, in many cases, our larger clients, they may have a portfolio of several thousand matters to be managed there. And so what we try to do is give them, you know, as much quantitative help as they would like to show where things might be cut or more things might be added. And so we're going to follow on here with a non-trivial example. It's a very large company and it has good IP management skills. And we're going to look at two law firms that both are I think of strong quality, so that we can, you know, see and show how kind of difficult some of this analytics can get, and how non-obvious you know, prosecuting analytics can be. So this is just a dashboard tool we use. It shows, you know, counts of RCEs, it counts RCE of office actions. You know, kind of gives an interview to interview activity. We look at allowances after office action responses. You know, we look at examiner activity, extension activity, and also any restriction requirements that go into this. And I think, Tom, you had some special comments for this this slide.
Yeah. So let's see. Yeah. So on this slide, we can see that you can take a look at what percentage of office action responses have interview activity. So if you take a look at, this is the like the second down on the left bar chart. What's interesting there is to see the rate of interviews increase, you know, only kind of near the end. So this is one of the things I would look at this and say, would I have fewer office actions were I to push some of those interviews up towards the front? And if you look at the slide below that, or as you dig into some of those matters, you could use that to drive saying, well, okay, of those 203, for example, that had interviews at the first office action, what number of those actually got me closer to an allowance, right?
Yeah.
And then as you look towards even like, let's take a look at the top right slide, the RCE activity. One of the things that I like to do with a chart like this is, obviously this is a trend that I'd like to see in a portfolio of fewer RCEs in the later numbers because it gets expensive. But in that 6+ region, there's 14. I might just dig into those 14. What's going on there, right? Maybe 10 of them are really critical technology areas, maybe original filings in a large family that are worth keeping alive because of a continuation practice. But maybe there are a couple outliers that have just kind of flown under the radar. If you're at 6+ RCEs, it's probably fair to guess that it's been around for quite some time. So it's worth questioning, is this technology still relevant and valuable? And then let's maybe just take a look at the bottom left. We talked a little bit about, or Mark, you mentioned extensions, and of course extensions are a place where costs can really come into play, depending of course on practice and kind of who's driving the extensions. But there's, you know, out of the, if you compare the bottom left with the top left, out of the 2204 office actions, first office actions, more than half of them go into extensions. And that seems to be close to the trend. It's about 50% take extensions. And I would want to ask, is that in line with what I would expect? Am I causing the delays with my internal folks and inventors and direction to outside counsel, or is that outside counsel driven? And is that, you know, maybe a quick place where I can start to rein in some budget simply by getting some of those extensions reduced? right? And that's a nice place to rein in budget without having to require less work from outside counsel.
And this shows, if you have a dashboard like this, and you're sharing it with your client, you have all sorts of opportunity to make substantive changes happen, and get those changes in place. It's kind of an easy way to find money for your group of clients to trim their portfolio as they go, and they don't get to the point where they're 6 RCEs into something.
Mm-hmm.
Mark, let me hop in here
Sure.
on another PTO tangent. Sorry again, but a couple of these graphs that Tom pointed out, especially the interview activity and the success rate of the interview, there's a slight difference, 22% at the front end versus 18% at the back end, but it's going down. And the reason, from a PTO perspective, and I think for a best practices for prosecution, the earlier you have a discussion between the prosecuting attorney and the examiner, the better. Your success rate is going to be higher to get that allowance, because you break down a lot of barriers in the written word, and positions aren't taken don't become so unmovable over time. So I just encourage, I think this slide actually shows it, and encourage more interviews at the front of prosecution. Again, this is a tangent, so I apologize, but when I see it, I like to at least speak up.
Absolutely, appreciate it. So if we could jump to the next slide. Thank you. So this jumps into, we're comparing, this is live data comparing 2 separate firms with a very large client, with a highly sophisticated client who also understands and actively manages their portfolio. It is not a client of the firm, so let me just be clear on that, so that we have no interest or disclosure issues with these statistics. Plus, they're all public. So when comparing one firm against the other, I mean, if we stop and start at the top qualitative level, it looks like we have a clear winner. But as we will go into these other analytics below this, that this is probably not the place to stop your analysis. We would like to look at the business and products that they're covering, the inventors associated with this, the tech centers that they're filing, even in how these things are being put into the news and used in the news. So there may be a myriad of reasons, is what I'm trying to say here. And let's jump to the next slide. So when we compare claim expansion and pendency here, firm 1 and firm 2, I mean, firm 1 writes shorter patents, and their allowed grants are actually shorter in words. So these are total words here. I also like to use the metric of unique words as we're looking at qualitatively at claim writing.
And Mark, these are lengths of claims, right?
Yeah, this is length of the primary first claim,
Okay.
independent claim.
Yeah.
And so this is just it's an easy way to kind of look at the performance. And this is across their entire work, so this is averaged across all their work versus anything onesie twosie looking at. So as we're looking at this is another way to look at, are they more wordy? More claims is one way to look at them. More words, you would probably getting narrower coverage as you're going through this.
I mean, if you look at this, and I'll just throw an observation in here. If we know that one firm has a higher allowance rate, which firm number 2 does, but close to 100%, this kind of would imply this graph that they're probably taking some dependent claims more frequently and running with them than firm number 1, because they've got longer claims on average. I mean, obviously you'd have to look at the actual work product to determine that, but that might be a logical supposition to make here.
Absolutely, but then you look at firm 1, they're actually taking longer to get broader claims through. So again, we'll keep investigating here. It's why we really want to caution on using qualitative analysis on top of this. Next
Yeah,
slide, please.
one other little observation too, just as if you look at the length of the claims, I mean, you'd assume firm 2 might be starting a little narrower on average, so maybe easier to get to allowance faster, or at least get to allowance. So it's just observations.
Correct.
To consider.
Absolutely. Next slide, please. And so now let's talk about office actions to allowance. And this is where some of the financial analysis starts to hit in here. So if we look at them, firm 1, firm 2 together, you know, their allowance rates and office actions that take to get to an allowance, you know, they tend to mirror each other. I mean, firm 2 is certainly doing less work, but, you know, the overall, you know, profile of the statistics is not greatly different. In fact, if you look at their average number of office actions per an allowed matter, it's 2.9 in firm 1 and 2.89 in you know, firm 2. And this, I don't think this is necessarily determinative. But one thing I do want to draw attention to is if you think about that, each office action probably costs you on average, you know, $3K. The APLO ranges or much more and much less than that. So if we pick the middle and say it's 3K, you know, if you have a client, if your client is, you know, in a way that drives you to more office actions, you could be spending an extra, you know, at least an extra 6K per filing if you really push the notion that you go 4+ office actions on it. So again, this is a way to put fiscal planning in front of your client or the corporate entity is doing the portfolio management, is that, you know, maybe think about a narrower start to your claims and get an office action allowance quicker and target things better. This is why, you know, analytical, you know, mapping of your claims at the earliest opportunity is something that I personally recommend we do as well, because that way you can, you know, target your claims much better than trying to, you know, cover the waterfront. I also would encourage you to target individual companies or individual products much more than you would trying to cover the waterfront with the broadest claims, simply because it costs you less to get there. Anyway, personal opinion. Next slide, please. RCE Prosecution Metrics. Again, this is another area that I find in many cases is driven by the company itself, because the co-actors at the company are, you know, is it a product line that is generating a lot of revenue, and, you know, anything associated with that product line we should hang on to for as long as possible. Again, we look at this, they're virtually identical between firm 1 and firm 2, which is also lends credence to my my push for you know, deeper analytics here. But in many cases, the inventors, especially if the company is full of prolific inventors, have a lot of say in this. This particular company regularly runs, you know, over 100 matters at 6 office actions or more. And so I did some analytics in that, and I looked at the RCEs in that respect. And literally every single matter that they went more than 2 RCEs on had at least 1 or 2 inventors who had at least, you know, 50 or 60 patent applications to their name here in the US. It compounds much more if there are multiple inventors on that. There were no other quantitative details that showed value in those patent filings, other than the fact that they had, you know, prolific inventors in it. So I think there is a preference to keeping patents alive if your inventor is a famous inventor. Also, I think the law firm, the experience level of the prosecutor is directly responsible for this as well. I think that, as Russ mentioned, the knowledge that you can go for an appeal rather than, you know, going the RCE route, I think is a direct factor in this as well.
You know, Mark, I'll jump in here. I think we touched on this last week a little bit, or maybe the first week, I think possibly, which is sometimes these RCEs are good indicators of which patents a company places a high value on. So they can be pretty interesting to look at from a competitive perspective too. So
absolutely,
really not prosecution management, but more identification of competitors' key assets, or even your own assets, because when a new person comes in and they've got no history with any of the cases and they want to figure out what's going on, this isn't a bad place to start. Like, let's take a look at the prosecution stats for all the cases I'm managing and kind of see which ones look aberrant, and inquire as to what possible reasons there might be for that.
Yeah, I think, go ahead.
Especially if they're in a large family, right? Because that gives you the sense that they're, it might be a large spec that they're spitting out continuations, and they've got one or two that are just being kept alive essentially for that purpose.
Absolutely. And, but what I found was curious is, I've seen a number of companies where none of that exists. There's no citation behavior. There's no family behavior. They just have prolific inventors in it. So again, maybe that's an artifact of the company, but always look deeper into these statistics. Next slide, please. So, an amendment performance and success. Again, this is another metric where, again, firm one has a little more success in zero claim amendments. They've been more thoughtful maybe about the claims they've written and gotten allowances on. But again, this, if you look at the ratios, they're not tremendously different from zero claims to 4+ claims. There's nothing that's really steps out as an outlier here. But so if we go back and look at the companies, a lot of what they do in their first claims they do drive a fairly broad claim scope in their first amended filings. They do take a prospect of trying to cover the waterfront. And, as you can see, they do tend to move fairly prolifically through the claim amendments. So again, active prosecution management here, establishing whether or not there's a value to amending, I think is a critical aspect to look for, where you can shave some cash flow and maybe repurpose that for other matters in continuation and such like that. Any other commentary from the crew here?
Not for me.
Okay. Well, we're about 6 or 7 minutes from the end here, so let's kind of summarize. The key takeaway here is that prosecution stats can either be very useful in how you do your financial management and your prosecution management. It is something that's entirely within your control. They can also lie. They can also be, if you don't look deep enough, they can, give you the wrong impression of the firm that you're working with, or of the client itself. I think it's a tremendous tool to use in cost management and also writing better applications if you look at it on your way through prosecution. I mean, if you wait till you take a snapshot and you see, I've got 110 matters in 6+ office actions, it's a lot later than it should have. The discussion is happening a lot later than it should have happened. Unfortunately, these statistics aren't readily used, I think, by a lot of corporate management teams. Because they do take work, and as we said, the outcomes of your analysis can't just be taken as statistical values without potentially ruining some of your other things that are going well for your portfolio. I'll let everybody else circle on this one if you all want to jump into
Mark, I'll tell you what I was thinking about, going back to a much earlier life for myself as an engineer, and looking at all of the statistics, the data that we would generate on a production line, and looking at your comparison of a couple of the firms. And what really comes to mind is the fact, and Steve's pointed this out before, that this kind of data helps you with outliers. It helps you establish boundaries or bands that are acceptable behavior, if you will, or acceptable performance, and focus your attention on the ones that fall outside of where you would expect, whether that's RCEs, a number of amendments, whatever, and put your focus on those to identify, dig deeper, and find out, why is there an outlier, why is there an anomaly, because those that are within the band of, shall we say, acceptable data range, it's going to be hard to differentiate between them. There's going to be a lot of variables that are influencing it, and hard to really distill it down to which one. So that just kind of goes for, your summary here on what you can do and what you can't do. Anyway, that just took me back thinking as an engineer about the statistical bands on the data that we were accumulating.
And I would also join on that and say that, the more you can use prosecution stats to help you target what you're actually trying to accomplish is an advantage using a patent in the marketplace. The less you'll spend on things that, 6 to 10 years down prosecution road that you say, oh, I didn't realize we were spending so much on this one. So go ahead.
Well, one thing that I would add too is this is, and we've talked a lot about, this is great for identifying those outliers where you might want to improve practice, but identifying the outliers kind of on the positive side of things as well, where things, maybe you got quicker allowances, costs were smaller, claims were shorter, et cetera, to identify if there are strategies that come out of that analysis that can be kind of propagated back into the rest of the portfolio to try and use this data, not just from overseeing what looks wrong, but picking out what worked well and reusing it.
Right.
Yeah, Steve Lumberg, I'd jump in on that a little bit and only say that, what I've seen happen over the last, number of years, and probably been happening for a long time, but there's an awful lot of cookie cutter prosecution process control that has become best practice, in the industry. And it's not a bad thing. It's good to have control over your prosecution practices. But what that might be doing is preventing companies from experimenting with different ways to, prosecute cases to see if they get better outcomes for less money or better outcomes for a little bit more money. And so, I think it's worth looking at these stats. It's worth kind of asking the bigger question, like, how could I use, my stats to maybe try to experiment a little bit? Maybe I should have, a fast track, where my goal is to give the prosecutor full discretion, but we want the cases turned around much faster instead of going through an elaborate corporate review process at each turn. And I know some clients give a lot of discretion, some clients don't. And there's no one right answer to that at all. But if you've only done it one way in the past, maybe the stats is a good time maybe to think about it. Maybe I should try some experiments, do some gaming, if you will, with, how you do stuff and see if you get different results.
All right, let's jump to the next slide here and kind of finalize and answer questions. I think we're down to the last minutes of the event here. Here's who we are and what we do. Okay, so anybody else have questions right now, or I think we've got a.
There was one question that Russ answered on the side about time slicing. If you got a minute, you could just say, Russ said that basically it's looking at the data based on, time and events that may influence the data. Is there any other slicing you had in mind, Mark, when you were using the term?
Well, I think that Russ's point is right on there. I think that time slicing, though, can take you into product analysis much more deeply as well. When a product was launched, when a particular company came to realization they had something inventive in their thing. So time slicing in quarters, or in resolving to news releases even, has I think a very good benefit as we're working through this. And unfortunately, the natural language tools out there do not do this extraordinarily well at this point. They can identify aspects, but rarely do they provide a good answer versus a human review.
Well, with that, I guess we'll wrap it up for the day. I want to thank everybody for listening in today, and hopefully we'll see you again in a couple of weeks when we dive into the examiner analytics, where we've got a lot more interesting insights to discuss, and we've got some real life use of that data that we're going to share, and how it's used by some of the prosecutors and leading law firms. So thank you very much, and we'll see you in a couple of weeks.
Thank you.
Thanks.